Hey folks, welcome back to the channel. Today's case features a fractured co-parenting relationship. A father, fresh out of prison, is fighting for supervised visitation, but the mother isn't making it easy. She raised some serious allegations about past incidents, but didn't report them to the police. Instead, she called his bondsman, ensuring he'd ended up back in jail. To make things worse, she's now hesitant to use a court-appointed third-party facility for visitations, citing safety concerns. Did she even think about what she was signing up for when she had a child with him? Who knows? One thing's for sure. This isn't about co-parenting. It's about grudges and regrets, with the child stuck in the middle. Let's dive into this chaotic hearing and see if the judge can untangle this web of bad decisions.
And this is Bell County Calls number 23 DFAM, 340,825. This is in the 169th Judicial District Court of Bell County, Texas. And this is in the interest of Taylor minor child. Non-custodial party being Brandon Christopher Taylor. Custodial party being Chanel Bree Jones-Washington. This matter is before the court on a petition to establish parent-child relationship. The court will take judicial notice of the court file. Note for the record, both parties are present today. Both parties are previously noticed and served. And that the parties, the state's present, the ad litem that was appointed in this matter to represent the child is present. And we will further note for the record that we've been operating under a temporary order establishing since the 9th day of April 2024. Anyway, at this time, both parties are present along with the state and the ad litem. I'm going to go ahead and have the ad litem and the state make an opening statement telling the court what they're requesting we do here today. As I always tell people, I'd let the lawyers make the opening statements. All I want to know at this point is what we were trying to accomplish legally today as far as this here is concerned, and that obviously involves the lawyers telling the court what their requests are. At the end of the hearing, if either party wishes to make a closing statement or a closing argument after the court has heard their testimony, then as their own legal representative, they can do so. So at this time, I'll ask the state for an opening and then the ad litem. And then I will. I also want to make sure if this is going to be a final or a further temporary order. Thank you.
Thank you, Your Honor. The state's preference is to have a final order if appropriate. If it's just a further temporary order, Your Honor, the state's main objective is to ensure that support is actually covered in this case. When my colleague obtained the temporary order back in April, Mr. Taylor was still incarcerated. It's the state's understanding that he actually got released from TDCJ in July, and so support would have been appropriate after that. And it's the state's understanding that there's no dispute as to Mr. Taylor being the person to pay support, and I believe he's also in agreement to paying cash medical if Ms. Jones-Washington still has the child covered that way. And then, Your Honor, the state was also seeking retroactive support for a period of 3 months prior to Mr. Taylor's incarceration. Again, I don't believe the financial is an issue other than Ms. Jones-Washington just advising that's not her main concern. I believe the biggest contest, Your Honor, will be with regard to what, if any, access Mr. Taylor has to his child. And it's the state's understanding that the proposal for a supervised visitation center brought by Ms. Garcia was not agreed to by Ms. Washington, but Mr. Taylor was willing since it would give him access to his daughter.
Thank you. All right, Ms. Garcia.
Yes, Your Honor. Spoken to the parties, and let me just start with my recommendation is going to be exactly as Ms. Bongat explained. It would be that the father pay guideline child support and whatever other medical support, cash medical, he should be ordered to pay in the child's best interest. With regards to his contact, I do believe that he should have contact with the child. There are some concerns. The mother's testimony will detail what those concerns are. Mainly, the mom has concerns for the father's extensive criminal history, as well as some incidents that occurred between them where she alleges that he used a gun to threaten her, and that this occurred in the presence of the child. No charges were ever brought with regard to that. However, it's her concern. She wishes for
you may proceed, Ms. Garcia. Thank you.
Yes, Your Honor. And that is the mother's concern. The father does have extensive criminal history, but it doesn't relate to anything in the way of an assault. He does have, it looks like he's got several felonies. Most of them are of nature of drug possession. There are some gun charges, as well as some evading, and it looks like he's been to prison a few times. He is on parole right now. There's nothing in his bond conditions that would prohibit him from having contact with the child. This is a 3-year-old child. Again, and I believe that it would be in the child's best interest, and my recommendation today would be that the father be able to have a relationship with the child. However, that needs to be under monitored circumstances. And since I don't believe that it's appropriate for the mother to be that supervisor, nor do I know of any other person on the father's side that would be appropriate for supervision, my recommendation today would be that occur at a supervision center, visitation center, Your Honor, and that's my recommendation.
All right, guys. Basically, what I'm hearing here is that it's going to be kind of hard to make this a final. But here's the deal. Obviously, Ms. Washington, he's the father. He's gonna. I'll get some data on why you want what you want. But presently, this man, he has completed his debt that he owes the state of Texas or wherever he was, as far as his criminal activity is concerned. Right now, my understanding is based on the fact that he's here today and not somewhere else, that he's a free man, and this is his child. So I've got to come up with something. And if it can't be, and it's got to be as requested by the ad litem, I'm probably looking at doing this as a temp order to see how those visitations go at a visitation center. That's what those things are for. I hate using them because they cost people money, and I'd rather the money go toward child support. But the circumstances are the circumstances. So let me get some testimony. Let's find out what's going on. And obviously, I'm really more interested in. I'm interested in what happened before. In the past, but I'm more interested in the current circumstances involving the father, his job for information, his ability to maintain that job, and to make sure he's. I understand he's on parole, and make sure everything is going okay with his parole. So anyway, I'll ask both of you at this time to raise your right hands and let's get some testimony, please. And I can unmute yourself. Please unmute yourselves, and I'll swear you in. Thank you. All right, Mr. Taylor, you're still muted. But do both of you solemnly swear or affirm your testimony you're going to give this court today is the truth, the whole truth, and nothing but the truth will help you?
I do.
Yes, sir.
All right, thank you both very much, and I'll allow this state to go ahead and start with the questioning. Ms. Bongat, I need to know where the parties are located as far as their residency is concerned. Thank you.
Thank you, Your Honor. The state first calls Mr. Taylor. Sir, what is your full name?
Brandon Christopher Taylor.
And sir, in what city do you live?
Killeen, Texas.
And sir, were you able to hear my opening statement to the court?
Yes, ma'am.
And sir, was I accurate in telling the court that you have no problem paying guideline child support based on your earnings?
Yes, ma'am.
And sir, is it correct that you have at least one other minor child besides your daughter?
Yes, ma'am.
And sir, how old is that other child?
He's 6.
And sir, do you have to pay support for him, or does that child live with you?
No, he don't live with me, but I take care of him. I get him every weekend.
And sir, is there a court order for support in that case?
No, ma'am.
And sir, as far as your daughter, what, if any, contact have you had with her?
I haven't seen her since she was born.
And is it correct, Mr. Taylor, that for all but 3 months of her life, you have been incarcerated until your release?
Yes, ma'am.
And sir, as far as the support amounts, are your circumstances the same as they were back in October and then the most recently December 11th?
Yes, ma'am.
And sir, as far as medical or dental coverage, does your employer offer that?
Yes, I reckon they do, but I don't go through them.
And so, sir, if testimony from mother is that your daughter has other coverage, you wouldn't have a problem paying a cash medical amount?
If I got to do what I got to do, I don't mind.
All right, sir. And so based on the numbers you provided me with your current wages being what per hour?
14.
And how many hours per week are you expected to work?
40.
And how long have you had this job?
I've been at this job for about going on 4 months.
And who is this exact employer?
Central Texas Scrap and Metal.
And so, sir, based on that information, you understand I've calculated that cash medical support would be $54 a month, and then child support would be $361 per month.
Yes, ma'am.
And then, sir, as far as the retroactive or back child support period, other than those 3 months that you were out, was there any opportunity for you to send funds to Miss Jones Washington for your daughter?
No, ma'am.
And those 3 months that you were out, sir, is it correct that your employment then was roughly $11 an hour, 2 days a week at something like Texas
Oh, yes,
Roadhouse?
yes. I did work at Texas Roadhouse, but I wasn't really getting any hours like that.
Okay. And so, sir, based on that information, again, understanding it wasn't very frequent, you understand I calculated a total of $888.18 as a back child support judgment.
Now you never told me that, but I'm hearing it now.
And sir, if the court grants that judgment, would you have any problem repaying that at $55 a month on top of your current child and medical support amounts?
I have to do what I got to do.
Okay. And then, sir, as far as the temporary orders, you were not present at that hearing back in April, correct?
No, ma'am. I was in prison.
But since then, sir, you've had an opportunity to have that information sent to you and to review it, correct?
Oh, yes, ma'am. I wrote back from prison.
Yes, sir. And so the current order, you understand, shows that Ms. Jones Washington is sole managing conservator and you are possessory. And with that information, sir, you've had a chance to find out what that means and what you're entitled to based on that, correct?
Could you explain that to me all the way?
Well, sir, when we went over this order, you had a chance to learn what those mean, correct?
That's why I was asking you. Could you go over it one more time for me so I can fully?
Got it, sir. So in that order, mother has the right to decide your daughter's domicile, and this court said you had no rights until further order. Does that sound
Oh, okay.
familiar?
Oh, I got you. Yeah. Yes, ma'am.
And then, sir, as far as the visitation, the court had said you don't get any until further order. Does that also sound familiar?
Yes, ma'am.
And part of that, sir, was this court finding, based on the information it had at the time, that you had had a history or pattern of family violence involving Ms. Jones Washington or any other family members.
Yeah,
Were you
never
able
had
to
that, but
recall that as far as what's in
no.
the order?
I heard it when you told me about it.
Okay. And sir, did you provide any additional information besides your testimony today for the court's consideration?
No, ma'am. I just want to get this stuff done. So I just want to take care of my kid and pay what I need to pay and just be able to see my kid. That's all I'm trying to do. I ain't got nothing to say. I don't, I ain't trying to do none of that. I'm just trying to take care of my business, what I'm supposed to be doing.
Okay. And Mr. Taylor, would it be fair to say that you and the mother did not end your relationship in a good way?
Not necessarily, no.
At this time,
We
sir,
really
do
never had
you
a
and she,
relationship.
sorry, please continue.
No, I'm sorry. I said we never really just had a relationship like that.
Okay. Then, sir, as far as right now, do you and she communicate at all?
No,
Do the
no,
two
ma'am.
of you know where each other lives?
No, ma'am.
And before you got incarcerated, sir, was there any method of communication that worked best for the two of you?
Uh, Yeah, I mean, the telephone. I mean, yes, ma'am.
All right. And so, sir, another thing in the order was it kept Miss Jones Washington's contact information, including physical address, uh, out of the order so she doesn't have to disclose it to you. Do you have any problems with that?
Yeah, I don't need to know where she live at. I just want to be able to see my kid.
Okay. And then as far as your information, sir, do you have any problems with it appearing in the court's order?
What's that?
Your physical address, phone number, email appearing in the court's order. Are you fine with it being there?
Not really. If I don't have to have it, that'll be fine. But I mean, if I do, I don't mind.
And I guess the big question is, sir, will the information being there put you in any harm's way or cause harassment?
I'm not sure. I mean, I don't think so. I mean, I don't know.
Okay.
I don't. Yeah, I think if I don't, if it's like that way, I think it should be both ways.
Okay. And sir, based on my questions so far, is there anything you'd like the court to consider that needs more detail?
No, ma'am. Like I said, I'm just trying to. No, I don't do nothing but work every day, take care of my kids and my son, and I'm just trying to. I just
And
want to
sir,
pay what I need to pay.
yes, sir. What is your exact work schedule?
I work Monday through Friday from 8 o'clock to 5.
And then any weekend work at all?
No, ma'am. I get my
And so,
son on the weekend,
which weekends do you get him?
every weekend
And
since
is
I've been
it
home.
from what time on Friday or Saturday do you get him, and when is he returned to the mother?
When I get off of work, I usually do a little running around, and then I grab him. We pick him up, and I have him to Sunday night.
And sir, your current home situation, is that home or apartment?
It's an apartment.
And in this apartment, who lives there besides you?
Just me and my girl.
Okay. And so she doesn't have any children. Your son is
No.
with another person?
Yes.
Okay. Thank you, sir. Your Honor, I pass this witness.
All right, thank you very much, Ms. Bongat. Ms. Garcia, your witness.
Mr. Taylor, you earlier in your testimony, you testified that for all but 3 months of the child's life, you've been away from the child. Is that correct?
Yes, ma'am.
Okay. And during those 3 months, I guess that'd be more so at the beginning of the child's life, correct? Those 3 months, or are we referring to the 3 months since you've been out?
Run that by me one more time. I'm sorry. What?
So I guess I probably asked the question funny. Essentially, what I'm getting at is those 3 months, was that since you've been out, or is that 3 months where you had some sort of interaction with the child when the child was first born?
Oh, when she was first born.
Okay.
Yeah, I
And,
haven't. I think. Oh, I'm sorry.
no, you're fine. And you were going to say what? That since you've been out, you haven't had any contact? Is that what you were going to tell us?
No, ma'am. I haven't seen her.
Okay. Those first 3 months when you did have contact, was that when you and the mother were you guys living together at that point?
Oh, absolutely no. We never
Okay.
lived together.
Okay. How would that contact come about? What?
I would just I would just go see my daughter.
Okay.
See, I mean, to give you the gist of the whole situation, I had I was with somebody, and I
Mhm.
stepped out of my relationship, and I messed with her. Me and her never had a relationship. I just ended up getting her pregnant, and that was the root of the problem. She don't really like my lady, and that's really the root of the problem because I didn't choose her in the relationship. So
Mhm.
she has a big problem with me, and that's
Okay.
really the moral of the whole story.
Okay, but with regard to the contact with the child, you would work out visits with the mother of the child, correct, for these visits?
Yes, ma'am.
Okay, and where would those visits occur?
Uh, at her house.
Okay, and that went on for 3 months?
Uh, not, I mean, pretty much. Yes, ma'am.
How often would those visits occur?
Just whenever she called. Like sometimes she might needed me to watch her while she run to the store or something, and I would do that.
Once a week, maybe, or more?
Just I don't really know just whenever she would call.
Okay, so just here and there?
Mm-hmm. Yes, ma'am.
Okay. And since you've been out, I think you testified you don't have any contact with the mother at all. Is that accurate?
Yes, ma'am.
Have you made any attempts to contact her through any mutual friends or acquaintances to try
Yeah,
to?
I have.
Okay.
I have.
All right. Were those attempts made to try to get visits, or what were those attempts made for?
Just to get an understanding.
Okay. Have you tried to reach out and see if you could coordinate a visit with your child?
I absolutely did. I did. I reached out and I just said, look, I don't want no problems. I just want to be able to take care of my kid and do what I need to do. I don't, whatever that was in the past, I'm behind all that. Like I say, I'm just trying to take care of my business. That's all I'm trying to do.
And what was the response to that attempt to make contact with the child?
I don't know. Somebody else. I don't know who it was. Somebody else responded. I really don't really know what they said. I guess it was a friend or something. They had said some other stuff. So I don't really know.
So nothing about the child?
No, no.
Okay. All right. You've got a little bit of history. You've got several felonies in your background, correct?
Yes, ma'am.
Okay. And those felonies, from what I can tell here, it looks like you've got some unlawful carrying of a firearm, unlawful possession of a firearm, ×2, possession of a controlled substance, and an evading arrest with a vehicle. Is that accurate?
Yes, ma'am.
Okay. Are those the only 5? I guess these are all felonies. Are these the only 5 charges that are in your background?
Yes, ma'am.
Okay. And you've done a little bit of time in prison for these, correct?
Yes, ma'am.
All right. And this last time that you recently got out, what specifically was that for? What charges?
It was evading arrest and possession of a firearm.
What are you on parole on for? Is my question.
Oh, what was I on parole for? I'm sorry, it's
What
kind of
are you on
breaking up.
parole for? Yes.
Oh, I'm on parole
Sorry.
for that. Oh, it's okay. For that right there, possession of a firearm and evading arrest. That's
Okay.
what I'm on parole for.
And how much more time on parole do you have left?
I want to say just like 2.5 years.
Okay. All right. And have you ever been charged with or arrested for anything with regard to any sort of domestic violence or assault?
No, never.
Okay.
No, ma'am.
Christine,
Have you
I'm not sure if it's me or you, but you seem to be cracking up a little bit. So if you want to turn off your video, that might
Oh.
help. Thank you.
Sorry, Judge, I'm at the courthouse and let me see if this.
I thought you were at your office. No, it's the courthouse. Right. Got it. So go ahead.
I turned off the Wi-Fi. Is this a little bit better?
It seems to be okay. Thank you.
Okay, I'll try it this way. If not, I'll just turn the video off. Sorry.
That's okay.
Okay. All right, sir. Has there ever been any incidents between you and the mother that included any sort of physical violence from either of you?
No, no.
Okay. And you're here today. It seems like you want to take responsibility for your child and you want to have visits with your child. Is that correct?
Yes, ma'am.
You don't really have a relationship though at this point because of circumstances with the child, right? It's been some while since you've seen the child.
Yes, ma'am. It's been too long. I haven't, man, she done grew up. I ain't even, it's messed up because my son haven't even got to see his sister. Like he haven't even got to never meet his sister.
Okay.
No, he got a sister and he ain't even never got to meet her. And he asks about her all the time.
Okay. And you're willing to start off, maybe if the judge makes a temporary order today, you're willing to start off with the supervision center supervised visits and see if you can progress to something else if possible?
Yes, ma'am. Whatever I got to do.
Okay. Pass the witness.
All right, Ms. Bongad, anything on redirect?
No, Your Honor.
All right, please call your next witness.
The state calls Ms. Jones-Washington.
Be back in a
Ma'am?
moment, Mr. Taylor. Thank you.
Ma'am, what is your full name?
Chanel Bree Jones-Washington.
And ma'am, who is the child in this case?
Janae Elizabeth Nicole Taylor.
And ma'am, how are you related to Janae?
I am her mother,
Who is Janae's father?
Brandon Taylor.
And Ms. Jones-Washington, were you able to hear my opening statement at the beginning of today's hearing?
Yes, I was.
And was that accurate as far as your position on moving this case forward?
It is accurate.
And then, ma'am, were you able to hear my questioning of Mr. Taylor?
I did.
And was there anything, ma'am, with regard to the support portions that you disagree with or want the court to consider?
I've already expressed that I don't need the support, but I know that the judge said he was going to rule it anyway, so.
Okay. And then, ma'am, for the bigger issues, you were the only person present back in April when the temporary order was done, correct?
Correct.
And much of that testimony resulted in judge finding that the family violence matter should be in there and you would have sole managing conservatorship while Mr. Taylor was possessory without any rights.
Correct.
And that's also why Ms. Garcia was appointed to represent your daughter.
Correct.
Prior to Mr. Taylor being incarcerated, ma'am, were you aware of his relationship with the 6-year-old he testified about?
I am aware that it was strained due to him having issues with his other child's mother, so he didn't get to see him like that.
Okay. And was Mr. Taylor correct in that you and he didn't really communicate while he was out, and that since his release, it's pretty much zero directly?
Since his release, zero communication. He has reached out. I've had my significant other say that he can't have any contact with me, just like he couldn't have contact with the child due to the court order. Prior to his incarceration, which was she was born in September. I believe he was arrested in November, so that means he was only out 2 months with her, and he only saw her a handful of times. And he was correct when I believe I called him twice to watch her until we had our incident, and he left my house and was never to return, and he never returned, and he was arrested shortly after.
And then, ma'am, as far as the non-disclosure, you're asking this court to continue that so your physical address isn't public and you don't have to update Mr. Taylor if you move?
Correct. I am part of the address confidentiality program.
And then, ma'am, given that your daughter is 3, how much does she understand about Mr. Taylor or any father-like figures?
She has a father-like figure already, but she does not know Mr. Taylor at all.
And, well, because, ma'am, I believe you were saying this court should not order any possession and access. Why is that?
Due to the incident where we got into an argument when his other child's mother came to my house, for her and the son to meet my daughter when she was 2 months. And we got into a big argument. He pulled a gun out, and I haven't seen him since.
And was that incident reported to any type of law enforcement?
No, I did not report it. At the time, I was scared.
Was anyone present besides you, the other mother, the children, and Mr. Taylor?
No, the other mother wasn't there at the time. She had already left. That was the reason why.
Okay. And ma'am, backtracking a little, as far as the temporary orders where your daughter had health coverage, has there been any change to that?
No.
Thank you, ma'am. And then, ma'am, I realize you and the father don't communicate, but is there any method you would feel comfortable with if it became necessary for your child to be with Mr. Taylor or to arrange any of that stuff?
I don't want any contact with him at all. Like, I fear my safety from him, and I don't want no contact with him at all.
Okay. Slow down. Here's the deal, man. That wasn't the question. I understand you don't want it.
I
but-
don't. Because it would just have to be through my significant other.
Okay, ma'am, I don't use third parties for these type of things, especially of other boyfriends and other girlfriends. That usually doesn't work out. I'm looking at having to give Mr. Taylor some parental rights here going forward. He's dad. Yeah, there's no way around that. Okay, that's my understanding. So I've got to set this up, ma'am, and the state was asking, is there any way to communicate? Because because there's got to be some communication between you and he.
It would need to be some type of text app.
Okay, well, we got a parenting app we can use for that going forward, ma'am. It's called App Close, and we can set that up and get that done. But it's to confirm things that have to happen going forward, ma'am. Again, Mr. Taylor's the father, you're the mother, and we got to come to some type of understanding how that's going to work going forward. So anyway, I'll let the attorney finish the question at this time, ma'am. Thank you.
Thank you, Your Honor. I actually passed this witness.
All right, Ms. Garcia, your witness.
Hey, ma'am, you indicated that this incident with a gun happened, but you didn't report it to the police?
Correct. I've said that.
Okay. Why, was the child present?
Correct. I was holding her.
Okay. And why wouldn't you call the police if you felt like there was a threat to you or your child?
Because he knew where I stayed.
Okay.
And I am the one who called his bondsman and got him locked up. So that was my way of getting him away from us.
I don't understand what you mean. What do you mean you called his bondsman and got him locked
Because
up?
I had bonded him out. He was on the gun charge part. Well, during the time I was pregnant, I bonded him out so that he swore he wanted to do right and be there for his child. So I bonded him out. And after that, all the other stuff happened, but why did I bring that up? What was the question again?
What do you mean that's why you called his bondsman and got him locked up?
That's why after that, when he pulled the gun out in my house in my apartment that day and I kicked him out, I contacted the bonds because he already had jumped bond.
Okay. All right, so nobody else witnessed it and you didn't call the police. And there's no other, you said there's no other witnesses, correct?
Yes, ma'am, that's what I said.
All right. And earlier you testified that you fear for your life of him talking to you and all that other stuff. But the thing is, has he even threatened you or contacted you or tried to do something to you since he's been out?
Since he's been out, he has not threatened me. He has contacted me. He has said that tried to see the child, which I know is a violation of the court order. But that's it. No threats.
Okay. And while he was in prison, I mean, did he send somebody to threaten you on his behalf, or did he do anything, to threaten you?
No, he couldn't.
Okay. Okay. Okay, I pass the witness.
All right, Ms. Bond, got anything on redirect?
No, Your Honor.
All right, I'm getting ready to go ahead and let the parties tell the court anything in addition that we need that they think I need to know. But right now, folks, I'm looking at I'd love to make this a final, but this is nowhere. This is not close to being a final at this point. I got to come up with a temporary order. Obviously, I've got to set up some type of access to the child, it's just he's father, your mom, and he has the right to have access. I'm probably looking at a access center for now. They're expensive, so I'm probably looking at a once a month deal or once every 3 week deal based on the cost. Ms. Garcia, I looked at cost about a year ago. Do you know what those? I know there's I think there's a center in Cove and Killeen, or there's one in that area, and I'm not sure what that would. You remember what that runs, please?
I haven't looked at them recently, Judge, but I think the last time somebody did it, it was around anywhere from between 70 to 100. I don't know if that's changed. I haven't looked. There's been centers that have opened and closed, and I haven't looked at it recently. I apologize for that.
All right, then. Well, I'll give you that task to see if you can
Yes.
find a center, and if there's more than one, see which ones are higher rated, and who's got the Google score higher, the whatever, and
Yes.
And we'll see about setting that up through them, but through that type of circumstance. But anyway, I was just trying to get a feel for what we'll have to do, because it's only 70. I was thinking it was a lot more expensive than that. So if it's somewhere reasonable like that, we may be able to set it up there twice a month if dad thinks he can afford it. But at this time, I'm going to go ahead and, ma'am, I'm going to allow both of y'all to tell the court if there's anything else y'all think I need to know that didn't come out in your general testimony. Again, I'm not going to go back behind his criminal convictions and going to jail. I'm looking at going forward. So that's what I'm looking at as far as your testimony is concerned. So I'm limited it. I need to limit it to we need to do that's going to be in the best interest of your child. So I'm going to start with Dad, and I'm going to come to you, ma'am. And I think I know it pretty much. I think Dad's been very vocal and been quite articulate in what he wants, but I'm going to give him another chance to tell me anything else that he thinks I need to know to make this happen. And then I'm going to give you that opportunity too. And then I'll let the lawyers make a closing statement. Thank you. So at this time, Mr. Taylor, is there any testimony any other testimony you think I need to know at this point, sir? You heard what I'm going to try to do here. So is there anything else you think I need to know at this point, sir?
No, sir. I think it'll be perfect. Whatever I got to do, sir. I ain't trying to cause no problems or nothing. I just want to take care of my kid and just be able to see my kid and have my son be able to see his sister. That's all I want to do. Nothing more than, whatever I got to do.
All right. And sir, you say you work Monday to Friday from 8 to 5, correct, sir?
Yes, sir.
All right, then. Ms. Washington, okay, thanks, sir. Ms. Washington, are you employed at this time, ma'am?
Yes, I've been employed.
All right, ma'am. What's your work schedule like?
My work schedule is Monday through Friday. I work 5 to 4:30.
All right. Do you work on Saturdays or Sunday, ma'am?
No, I'm off.
All right. Thank you. And you say
But I am in the Round Rock area.
okay. You live in okay. Oh, so you live in Williamson County. Okay. Thank you. All right. All right. Thank you very much. All right, then, ma'am, is there anything else you want to tell the court at this point?
I still don't feel like it's in her best interest to just be thrown into because regardless of how anybody else wanted to look at it, that I didn't report it. I still have my own issue with that. So I don't want to come in contact with him. So I'm trying to figure out how that will even work, with me dropping her off at a center, because it's going to be like me dropping her off to a complete stranger. So
Right,
how is that going to be good for her mental health?
Different centers have different
everything
process.
is for her,
Okay,
her best interests.
All right. Well, see, here's the deal, ma'am. Every center has its own processes, and we'll have to figure that one out, I guess. But the bottom line is, he's got rights to this child. He has not been terminated. He is the father, and fathers have rights to see their kids, ma'am. And I haven't heard anything today that's going to at least not let me give him some rights to see the child at a visitation center where everybody's supported to be safe. So
even though he disregarded the court order.
Okay. Now, ma'am, I'm not here to argue with you about it. I'm just saying you saying you disregarded the court order. What court order, ma'am?
The court order from April the 9th that basically stated that he was to have no contact with the child. Yet he sat there and admitted he reached out trying to have contact to see the child. They asked him.
Okay, all right, ma'am. That court order didn't order that he was not allowed to see the child. The order says at that time he had no rights to see the child. Okay, it's a little. I know you're not a lawyer. It's a little different, ma'am. But again, he didn't violate the court order. Okay, and it's not a motion for enforcement before the court on any type of violation of the court order, ma'am. So that's just something on the periphery. So again, he's dead. I'm about to set this up, ma'am, and I guess we'll just have to figure it then. Anything else, ma'am? Okay. All right, Ms. Bongat. I'll start with that light, and then I'll go to you, Ms. Bongat. Ms. Garcia, look like we're looking at Williamson County Visitation Center. So what I'm probably going to need to do is we will need to find out one that's appropriate, what the cost is, and do a reset to come back when we can get this set up where this gentleman, Mr. Taylor, can see his child. But based on the current circumstances, we're probably not going to be able to do this until after the first of the year. So because we're in the middle of holidays right now. But anyway, I'll hear what everybody, what the lawyers going to try to do on this one. Okay, and sir, yes, sir.
I'm sorry. Look, I have her Christmas gifts and stuff. So how would I have to wait to get it to her? How would that work? Because I got her Christmas stuff and everything, man.
Okay, well, she's 3 years old. Don't worry, sir. You'll be able to get her items, but I'm not sure when we're going to be able to do that. Because right now we got to find a center. And I want you to save those presents till you see her at that center. And right now she's in a different county. We got to find the cost. We got to find the schedule. It's the holidays. Getting something done the next 2 weeks is probably going to be problematic, sir. That's what I'm looking at. I'm just looking at the real logistics of it. So save your items, and I'm gonna have the ad light and try to find something in Williamson County, and we can set this up and get everybody on the same page as far as time, place, and date. Okay.
Yes, sir.
All right, then. So again, mom's in Williamson, so we're looking at doing something in Williamson. So Ms. Garcia, based on what we're looking at, ma'am, what are you asking us to do, please?
Yes, Your Honor, it's a 3-year-old child. She hasn't been able to see her father. Dad's here. He's interested in being in her life. He wants to pay support. He wants to have a relationship. I think he should have a chance. He's got these previous convictions. None of those are for assault or any crimes against children. There's nothing in his parole conditions that prevent it. And I'm requesting that the court allow him to start doing that. Unfortunately, due to the, I guess, bad blood between the parents, I would think, that the only way to start that would be some sort of supervised visits. But since mom doesn't want to be around dad and dad doesn't have anybody that could do it or that mom would be okay with, I think the best way to do that would be for the visits to occur at a visitation center for now and see if those go well. And then maybe at some point, Your Honor, we can come back and request that he have some better, more extended visitation that doesn't require a visitation center if things go well.
Thank you. Ms. Bungat.
The state's asking that this court go ahead and order support from Mr. Taylor based on his testimony and the state's calculations, ideally including retro, since there isn't really going to be a change to that, given how limited his time outside of incarceration was before we started temporary orders. And then current support, Your Honor, at 361 child support, 54 at medical. And I'll defer to the court as to whether you started earlier than January 1 of 25. Based on the parents' inability to communicate, the state would ask the court consider doing app close, especially with the prior order for non-disclosure that mom is asking be continued at this point. And then I'd still ask for the reservation of court costs until final, Your Honor, just based on this not being set or finalized today.
Good. All right, folks. What I'm going to have to do here, I'm going to go ahead and keep mom as sole MC, dad is possessory. I'm going to go ahead and start tweaking the rights I'm going to give him, and I'm going to take that under advisement. I've already done a quick search, and there's obviously a visitation center in Round Rock. I'm going to have Ms. Garcia investigate that visitation center and see about their rates, and I think the next closest one is in Austin, and there may be another one in Georgetown. But let's see about finding one closest to mom and seeing how they normally set what their criteria is and how they set everything up. Ms. Garcia, again, folks, with the fact we're running into Christmas and New Year's holidays, I don't have court for the next couple of weeks. So that's normally I'd have court for the next 2 weeks and we can get something done within that 2 week time frame. But right now we're probably not going to be able to get anything done until that first week of January, when I actually start having court again, as far as getting everything set up for the visitation. My apologies, sir. My apologies, ma'am. But obviously, it's Christmas and those are the circumstances. But I want to add, have the opportunity to definitely check out the visitation centers that are popping up here on the grid for me. So, Ms. Garcia, are you already going to be in court with us on any date that first week of the first week of January? It's actually the first falls on a Wednesday, so we're not actually doing anything. It's that second week of January. Are you going to be in court anytime that second week of January, ma'am?
I don't see anything for this court, but I have availability if the court sets it on that week.
All right, then. So let me see. All right. So again, folks, apologies. Like I say, but the first is on the Wednesday, and then we're still pretty much shut down after that. So let me bring back up the Zoom codes. Let's see what's available. Okay, here we are. We're still in December. All right, so the first day of the. All right, I've got okay. I've got slots available. I got a slot available on at 11:30 on Monday the 6th. I can move this Zoom code to Ms. Garcia, and we can see about it then. I've got Wednesday is the live setting, so
yes,
11:30 on the 6th. That works, Judge, for me.
Okay, that's great. All right, folks, here's what we're gonna do. I'm gonna reset this matter to January the 6th, 11:30. This is the same Zoom code. Ms. Garcia is going to get the opportunity to go ahead and look at all these visitation and access centers that are in the area, see which one she thinks is appropriate, and I'll have her contact both of you to see and to confirm that, sir, that you can what you can afford. And when we come back on that date, I'll be looking at setting up a visitation package for the first weekend that you're available, sir, which probably be that next weekend, which is okay, up the right calendar. So I'm probably going to try to see about setting up something at a visitation center for that next weekend, which is the 11th and the 12th of January. But if it needs to move to the weekend after that, we will, based on the cost and getting everything set up and making sure we can get an appointment. But when we come back on that date on the 6th at 11:30, we'll have that information and see and I'll have Ms. Garcia get in touch with both of y'all to make sure that everything can be made done and set up and ready to go on that date on one of those dates. So for right now, like I said, I'm keeping mom sold. I'm a named dad possessory, but I'm going to start giving him rights at the next hearing on the 11th. Ms. Garcia said there's nothing in his parole package that's going to keep me from starting giving him possessory conservative rights under the Texas Family Code, and I will do so. I'll go ahead and pick out which ones I want, and I'll announce those on the 6th also, or send those out to Ms. Bongat so she can start getting ready to incorporate them in. I'm gonna go ahead and order child support. I'm going to go ahead and order guideline child support as testified to and is agreed to by the father. Guideline child support, guideline cash medical, and that's going to start the first day of January 2025. I'm going to grant the retroactive child support judgment and order repayment of that at $55 a month. That's also starting the first day of January 2025. And like I said, I'm going to reset this matter to 11:30 a.m. on the 6th of January, and at which time we'll get the report on which visitation center will be the most appropriate and affordable and or the best one that offers the best security. We'll look into all those aspects of it. I want to, in fact, when I get through with this hearing, I'm going to go ahead and take a look at some of these myself And I'm gonna give Judge Bartson a call down in Williamson County to see if she's got a preference, who she might like for her cases, or talk to the CPS judge down there to see who they might like. So again, I'm gonna do my own research on this one to find the most appropriate place for this visitation to take place until we can get something else going. I'm gonna go ahead and order parties to get ready to set up AppClose. 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 Ma'am, you got to set it up, and then Dad will have to be invited to join in and get that set up. But I want to go ahead and get that set up. If you're running into problems with it, run that through Ms. Garcia, and she's authorized to help y'all get that set up. Because also, when we come back on that date, I will be looking at trying to set up some FaceTime visitations with the dad and the child through AppClose. AppClose has its own FaceTime function. AppClose has its own texting function. It has its own communication function. It's all built into the app. And that's what I want going forward, because the courts, I can get access to everything that's in that app if I need it to verify one way or the other, and I don't have to rely on he said, she said. I'll have written proof or electronic proof one way or the other. So that's why we like using AppClose.
This case is a reminder of how personal drama can derail co-parenting. The mother's claims of feared safety don't seem genuine, and instead of working with a neutral, court-appointed facility, she suggested her current significant other act as the go-between for visitation. That's not just bold, it's downright ridiculous, raising questions about whether her concerns are valid or fueled by animosity. At the end of the day, they created life together, and an innocent child is stuck in the middle of this grudge match. What do you think? Is the mother truly concerned for her safety, or are we just seeing more fuel added to the fire? Let me know your thoughts in the comments. And don't forget to like, subscribe, and hit that notification bell for more gripping courtroom moments. Thank you for watching. See you in the next one.